Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Bernand and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow. Ed, thank you so much for being with us today.
Thank you very much for inviting me.
So tell us about you and your journey to your current role as Associate Counsel at North Shore Law.
Oh, boy. Well, I'm called to the bar now 33 years. Prior to that, I have 2 law degrees, one from the University of Victoria, but a previous one from the University of Queen's Belfast. I lived in Northern Ireland for 5 years. And then we decided we were traveling at the time and ended up just doing law school. Came back to Vancouver, started my articles and practice, and fell into the world of wills, estates, and trusts litigation. I'm trying to think, about 1998 or so, I opened up my own practice as a sole practitioner, and that carried on until about 2023. And because of COVID, what occurred was, people were working from home or you couldn't keep staff very much. And I thought to myself, I live on the North Shore. Everybody's Zooming. Everybody's on the phone. I think maybe it might be better, instead of having an office right downtown, moving to the North Shore and just seeing what things were like. Because I was just sharing space. And a very good group, but it still was just sharing space. And I ran into a colleague of mine who I know on the North Shore. And I said, "What's rentals like?" And he said, "Are you thinking of coming over?" And I said, "Yes." And he said, "Come and talk to us." And so North Shore Law is a well-known law firm on the North Shore. They've got an exceptionally good group of lawyers in all areas. And I was very pleased that they asked me to join them. So I now have junior lawyers that I can work with and some other people in this area. So it's very good. Sorry about that long-winded.
Oh, that's great.
That's a long career. It should be a long story. Ed, what is estate mediation, and what role can it play in resolving estate and elder disputes?
Well, mediation itself is a form of dispute resolution. And in when you're dealing with it in regards to wills and estates, it will depend on the nature of the dispute that parties may have. Now, not all situations result in actual litigation being commenced. There may be situations where you may need a mediator to help resolve concerns between, say, a beneficiary and an executor, let's say. I have yet to be involved in something like that, but I could see it being very worthwhile. But generally, in my mediation practice, there's been some litigation commenced. So you've got opposing parties, and they, through their counsel, have determined that it might be in everyone's best interest to possibly meet and see if they can resolve it. And so mediation is a process of allowing the parties to engage on a without prejudice basis and try to resolve the issues that they may have. Sometimes it works, sometimes it doesn't.
Right. So when mediation, just specifically for estates, is involved, does the probate have to be issued at that point?
Not necessarily, because there could be an issue as to whether or not you're dealing with a valid will. And that might be the action. The action may be someone has challenged the validity of a document and you're involved in the litigation. And after the parties have had an opportunity to go through the examinations for discovery or exchange documentation, it might be that people might think that it may be worth an effort to try and resolve this without, you may still need a court order, but resolve it amongst yourselves and come up with a resolution.
So let's talk about that. Why is it better for families to consider mediation over just letting a court decide?
Well, as I tell all the people I'm involved with in acting as a mediator, you have much more control over the process in the sense that you can come up with ideas or forms of resolution that a judge may or may not be able to do. So in my opening statements to the parties, I tell them to think outside the box, and everybody laughs about that. But really, what's important is someone may have an idea, and I tell people you should ask that question so you have the information to determine whether or not it answers your question, but also it may open up an area where people just have not considered. And I learned that very, very early on in my professional career as a lawyer, when mediation was in its infancy and they were wanting lawyers to do mediation. I did a course as to, how should a lawyer conduct himself. And the mediator, I'm trying to think who it was. I think it was Gordon Sloan or someone of that nature, said that he had been in a mediation where one of the parties suggested an idea and it just opened the door. And he said, so never just be confined. So I think it's an opportunity, whether or not it works, but it's a good way of looking at things.
What are some of the common causes of estate and elder disputes that lead families to seek mediation?
Oh, well, there are any number of them. In regards to estates, it's usually how a deceased parent has dealt with their estate. And in a great many situations, it can be that it might be a second marriage for the elderly person, and they've provided something to the new spouse where the children are a little bit concerned that it might be too much. Or there's also concerns that arise that someone has maybe been pressuring the elderly person to do the will that they did, and they're concerned that they always understood that it was going to be an equal distribution, and then when mom or dad or whomever passes away, they suddenly realize it's not going as how they thought. So,
So what are the typical steps involved in a mediation?
Oh, typical steps. Well, normally the mediator is contacted by counsel, because generally I've yet to have anyone reach out to me to mediate something where litigation hasn't been commenced. But counsel or at some stage will have spoken to each other, and they may consider that the matter that they're dealing with may be able to be resolved by mediation. And that usually, in a lot of cases, happens after the examination for discovery and production of documents, which is a process in the court proceedings. And that allows each side to have a better view and understanding of the other side's position. And in many cases, that's when the lawyers say, you know what, we're maybe not that far off, and we just need to get these people to sit to, talk to somebody and have somebody else give some suggestions.
And so the mediation is agreed on, and then what happens?
Well, the mediation is agreed on, and prior to COVID, all the mediations were conducted in person. But now there's mediations on Zoom, it's an interesting process because I always found that in-person mediations, you have a greater sense of, I don't want to say control, but importance to the people, because they know that just down the hall there's the other group. Whereas on Zoom, I've heard of situations where people have, been in the middle of the mediation and left for an hour or two. And you think, well, no, this is a very important, matter that we're dealing with. So it can be very difficult in managing people. But if it's by mediation, you set up the time and structure. You also want to know who may also be involved in the mediation, because it may not just be the parties. They may want maybe a friend or a spouse there as a support person. So you want to make sure that everybody who is participating is aware of who's in the room, because you don't want to potentially have, a witness or something there who might be tainted in some way.
So how does the role of the mediator differ from that of a judge or an arbitrator in these types of cases?
Well, a judge or an arbitrator is empowered to make the final decision. A mediator is really someone who assists the party in coming to a resolution of their situation. Now, that can be in any number of ways, whereas a judge or an arbitrator is confined to what the law says. So, for example, the court may very well, in a will's variation, say, we're not going to vary the will because we think you're okay. Whereas a mediator might be able to get everyone in the room to say, well, is it really that too difficult to maybe possibly give this person something else, right? Or come up with constructive ways to benefit someone. And one of the classic things that I remember hearing about was there was an issue about someone, I think there was a house involved, should we sell the house? And during the mediation, it was decided that they would allow this person a life interest, which was not in the will. And a life interest is, as you know, is they could live in the house and there were certain things. And you know what? Everybody was fine with that. And it moved things over. Whereas a judge wouldn't do that. A judge would either say,
right,
you win or you lose.
So then you would typically go from that step where the mediation's been successful to then going to court for a consent or for an order.
Yes. What you want to do, especially when you're dealing with estates, is you've got an executor who is governed by the terms of the will. So when you're dealing with a variation of the will, if the will says we're going to divide it between A, B, and C, but then you have a lawsuit saying, hold it, I'm the fourth child and I should have received something, and you then do a mediation, and let's say they all agree we're going to include the fourth child. What you want is a court order varying the will to the extent that that fourth child is now included, because that allows the executor to know who he or she has to divide this estate in what manner. Okay.
Right. It's an order of distribution.
Well, it is, but it protects the executor because the executor is governed by the will. So an executor, this is where it gets somewhat interesting, because an executor is neutral in a will's variation, but you could certainly have situations where an executor is also a beneficiary and has an interest in the outcome of things. So you want to make sure you protect the executor.
So in your experience as a mediator, what contributes to a successful mediation? Or if you're witnessing lawyers or parties advocating, what enhances the chances of a successful resolution?
Well, I can tell you now that over the last few years, and I think most of the mediators are doing this, we don't have opening statements anymore. There was a time where you would have everybody sitting around a large boardroom table, opposing each other, and we'd have maybe the plaintiff go first, put their statement in this, and that can be very confrontational. And there's been situations where people have become very emotional about that. So we move away from that, and the mediation briefs are there, so we have an understanding of where people are going. And I think what's helpful is if you've got you know what the estate consists of. That's the main thing, because there's a lot of times when people come and we don't know the values. Oh, we don't know this, we don't know that. And I recall doing a mediation last year where that was one of the issues. And so it was agreed that they would do an accounting before they moved on to the next step. So that the mediation had to be adjourned. They did the accounting, and as far as I understand, that ended up resolving the whole matter. So that's you want people to be knowledgeable of what they got. So especially with wills variation, we need to know the size of the estate that may be in question.
I remember when I was mediating, I really noticed the difference in preparation in terms of success, and that the mediation was almost won or lost before it started by the party that came the most prepared. And also sometimes surprised that you would be mediating and people would not have appraisals, or they didn't have clarity on the tax consequences. And I thought, it's such a amount of time, effort, and expense. It would surprise me that parties would come to the table without all that information.
Well, hopefully, especially with the wills variation, if you've got an executor who's been involved and can say, this is what we anticipate, and we should maybe potentially hold back some monies because of CRA, we don't know. That's very helpful because, a lot of people, dealing with the death of a loved one is not only emotional, but getting into these financial things, they just think, what's going on? So,
right. So, Ed, what would be the optimal time to initiate mediation in the context of an estate dispute? And are there specific stages in the dispute where mediation is most effective?
Well, I mean, I've never done a mediation. I think I said this already before litigation had been commenced.
Mm-hmm.
And I think most lawyers would probably want to have at least the exchange of documents, so you have an idea of what information each side is relying on. And it will really depend on the nature of the dispute. If it's a wills variation, you may have a will which says, I'm dividing my estate to 2 of my 3 children, and I'm not providing to my 3rd child because I never saw that child, which is a common comment. And now, so all of a sudden, that child who's brought the claim sort of brings in the box of Christmas cards and photographs and the letters between him and the parent, and and the other side says, maybe we should think about how we're going to deal with this. Some people like to see do discovery, because that gives you an opportunity to view the other party. How good are they? Do they come across as a truthful person? And are they, or can you undermine their credibility or anything of that nature? So that's where that will depend on that.
So Ed, you've had a wide variety of counsel in front of you. Do you feel that there's different styles, and do you feel that one style might be more successful than the other? Like I understand there's the facilitative style, which is more give and take. Then there's evaluative, where a mediator might kind of tell the parties what he or she thinks a judge might do. What's your experience with that?
Well, I don't fit into either box because I look at both sides. And sometimes facilitating is helpful because you can just maybe throw some ideas out there to maybe let them think about it. Have you considered this? Have you thought about this avenue of discussion? Evaluation, again, is when you're getting to a point where, okay, you're at this stage and you really think, it's still who knows, because we don't know what a judge will do when they hear all the evidence, and you're so close, do you really want to spend the tens of thousands of dollars to go in front of a judge and not have an end result, whereas today you can resolve things. Style of counsel, everybody's different. And you just have to take them as they come. And I can tell you that when I do my opening of an introduction at my mediations, I will not condone any disparaging remarks. Okay, so normally in a Zoom mediation, people are in their sort of separate rooms. But if we come together and if somebody wanted to talk to somebody, no one says anything until the person's finished, and you have to be respectful. If not, I will cut them off. And same in the various rooms where the lawyers and the mediators are. I can get a sense if people are now saying disparaging things about their relative or whatever. I'll just say, calm down. That's not what we're here for. Let's focus on what we have to deal with. And so, the ranting and the raving about, when we went to court, we'd get a 90% and all the rest of it. Well, we're sitting around this table now. So if you thought you were going to get 90%, why are we here? Right? And you also have to manage things where if mediation is a compromise, you have people who, the first offer might be somewhat less than they anticipated and they get very upset and insulted. And you have to say, no, let's think about where you go from there. Okay.
Right. As part of that process, because you discussed about size of estates is obviously important. Mediation might cut costs. Do you find that people are more willing to accept mediation in smaller estates, maybe say under $500,000, but over 2, 3, 4 million, they're going to dig in?
I think sometimes with the smaller estates, our practice, those who are practicing in this area now, we've got a lot more people joining the area. Those who practiced a few years ago and could see the modest estates would be able to pick up the phone to the other counsel and say, listen, I don't think either of our clients want to pay us most of what they're going to get, right? So, but again, people will, rattle sabers and all the rest of it, and we'll go to court and everything, and you have to keep bringing them back to the fact that what are we fighting over here, and what would a judge potentially do? A judge may not vary a will if it's very small. right? And given the circumstances. So at the size of the estate, millions of dollars, yes, people's eyes brighten up when they've got, lots of money. But again, the costs incurred, mediation's still a potential thing to dealing with it. So,
So what kind of ethical issues do you encounter in mediating these types of disputes?
ethical issues. Well, first of all, I tell everyone I don't give them legal advice. They have counsel to do that. And that's very difficult sometimes because some parties will be self-represented. And it's very difficult to make sure you want them to understand what potential ramifications are. I haven't come across anyone lying to me, but if they did, I would be very upset, especially if it was counsel. I think they're very open and concerned that way. We also want to make sure, I always want to make sure that ethically we understand who needs to be involved in this, because sometimes you may have, other minor children or someone who's under a disability, and are they being properly represented? And you're going to need court orders for that sort of thing to do it. You can't just sort of, go to the bank and divide it all up.
Well, and that sort of leads to the next question. You've sort of touched on it. How do you make sure that you maintain neutrality and manage the power imbalances in the mediation process? Well,
I always explain to the people that I'm dealing with that they can be fully confident in me and tell me anything they want. Anything they tell me is held in confidence unless they tell me otherwise. So because some mediators will just hear everything, they'll go back over and say, so-and-so said this or that. No, I specifically ask people, all right, you've raised that. Is that something you want me to let the other side know now or later on? And they'll give me instructions so I know I can be neutral. And that's really helpful because that gives me some idea where they might be going. And later on down the road, we might be able to say, well, do you remember about an hour ago? And neutrality, they have counsel. And if I've got some issues with anything, I will sometimes say to counsel, I want to speak to both of you independent of your clients and just raise some issues that I might see. Okay.
So what about when you're dealing with really high conflict families or parties that are particularly entrenched? What are some strategies you use to try to reach resolution?
Well, everybody's usually entrenched. So, when they start, they are.
Right.
We're right, you're wrong sort of situation. I try to get to understand the people I'm dealing with. I mean, I've had situations where the issue was in regards to some real property, and it was in joint names and transferred this way and that way. And I went in and I got some background about the person who had passed away and discovered that they had immigrated to Canada. I said, well, that's interesting. And they, all of this. And I said, well, okay, I understand that background because part of my family immigrated and they worked really, really hard to create the wealth they created. And this particular person didn't have any children, so she was providing initially to her siblings and then possibly to the siblings' children. And I said, what was the auntie's real thinking here? And I got that one side to flip over, and we resolved it because they started saying, yeah, I think if Auntie was sitting across the table, she'd be saying, but getting into the background, what's the history of this? Why do people think that they are suddenly entitled? But the person who created this situation, why did they do that? And I think that's really important. And just understand, because people can be entrenched just because they feel, well, we've got a will. And a will's a will. We've all heard that statement before, but they don't realize in British Columbia that that's not necessarily the case.
Well, and also maybe sometimes the wills aren't particularly well written.
That's true too. That is.
Like describing exactly why she made that decision or sort of the background for it.
Yeah.
But Ed, how can mediators address the situations where there's allegations of undue influence or concerns about a party's capacity to participate?
Well, those those are tough because usually there's going to be some medical evidence supporting one side or the other. And undue influence, depending on what the nature we're dealing with, I mean, if it's a transfer of say a joint bank account, and under the law in Canada and British Columbia is that unless it's a true joint account, there's a presumption that you're holding it in trust for the deceased person, and explaining that to people. And sometimes situations arise where, people say, oh, it's undue influence. She was whispering in Auntie's ear, but hopefully there's somewhere, hopefully Auntie went and saw somebody and told them, because you'll now see in a lot of wills that I've created joint accounts with A, B, and C, and these are true joint accounts or something like that. But undue influence allegations, you've really got to say, well, that if it goes in front of a judge, what is a judge going to say? Is the judge going to say because you went and had tea with Auntie every Sunday sufficient, or is it more, well, hold it, you've got some difficulties here because I noticed that not only you were taking Auntie to the bank, you're the one signing the check sort of thing. You've got to consider that sort of thing.
Right. And I always go to those joint accounts because this has been around since 2007 or 2008, and it's still not well known, largely with the public.
Well, it's not well known with the public, and it's sometimes, when you think about it, sometimes people do this, and the person it usually arises because the person who's received the funds says, oh, it's mine. When in fact, no, it was never intended to do that. And I've been involved in a situation where the person put it into joint names with I think the eldest child, and the eldest child understood that it was to be used to, pay those administration fees when somebody passes away. One of the other siblings said, no. And she said, this is what's happening. After this is all paid, it's getting divided the 5 ways as the will said. Now, there was nothing written down by the mother, but everybody, all the other families said, do it. This is what you got to do, right? So, I mean, it's helpful if those who do these things write things down.
So maybe we should clarify with our listeners, because a lot of people might not be aware of this, but generally speaking, if people are spouses, if they hold either a bank account, investments, or real estate joint, that the presumption is that it rolls to the survivor, i.e. it's the survivor's property on death.
Generally speaking, yes.
Generally speaking.
I agree.
But generally, if it's anyone other than a spouse, i.e. often an adult child, the cases in 2007-8 were Pecora and Marsden, and the presumption is that adult child holds those funds in trust for the estate unless there's some sort of clear intention that it was meant to be a gift. And I think that's what you're referencing, that a lot of people don't necessarily know the law of that.
Even the institutions are joint account. No, it's theirs.
Right.
No, I know. And the thing is that, some people, a lot of people who do, I'm sure you're aware, when they're doing their wills and estates, they think, well, I don't want to pay a lot of probate fees. And so they don't want to, they don't want to give this money to the government. So, I'll put it in joint names with child or whomever, and I know they'll look after things. But to be safe on that, you should make sure you have something in writing to indicate that.
Yeah, the take-home message to listeners is never, ever just unilaterally set up joint tenancies unless you've received legal and financial advice and you clearly document your intent, because unfortunately those jointures, which was intended to save arguably a relatively nominal amount of probate fees, unfortunately often result in disputes that can cause a lot of expense and delay. And
That's
then
true, yes.
You've got people like us and Ed, and next thing you know, it's a couple of years later. And
More than probate.
More than probate, yes.
More than
very much
probate.
so, yeah.
How does the involvement of legal counsel influence the mediation process?
It will depend on counsel, but hopefully, I mean, as Nicole mentioned earlier, if people are well prepared, it's very helpful. Because then not only we may know the size of the estate, but also they'll have an understanding of maybe the dynamics between people. And they can also be very helpful in just letting their client know what options are out there. And I think good counsel will have had some sort of strategic plan when they went into the mediation.
Mm-hmm.
We all know it's a compromise. So sometimes people say, well, we'll start with, with our highest because we want the most, and where's our drop dead line?
Yeah.
And why is it? Why is that number the drop dead? And that can be helpful with good counsel who can explain to their clients who might say, well, what about, this and that? And they say, well, just a second, we're here. Let's hear what they have to say. And maybe next week you can be actually enjoying this benefit and not have to wait another year and a half.
So let's talk about that. What does success look like at the end of a mediation?
Well, it's a compromise, right? And people have to understand that going in is that it's like any negotiations, you may not get 100% of what you want, but hopefully you're going to come away with a sense that one, it's been resolved and there's an end to this situation. And you can move on with your life. Now, in a lot of these situations, you don't expect everyone to hug each other, given what they've gone through, and you may or may not, recreate the family, collegiality. But I mean, it's interesting. I've had one just recently where we, the two parties, after they've resolved it, have had to work together to help administer and do some things on the estate, and it appears that they are getting along, which is positive. I think it's very positive. But also, I think about the three individuals involved, and that's in their character, all right? And so, a good mediation is that you're not going, it's done, it's finished, and some people may be upset that they didn't get the whole thing, but they've got a result that they have a certain result now, rather than thinking, well, if we go to court, what happens if Mr. Justice or Madam Justice, doesn't believe me or my witnesses, and guess what? You don't get anything.
So how are agreements reached during mediation formalized and enforced?
Okay. Well, hopefully, I always ask that the counsel have either a junior lawyer there typing things up as we're doing things. But when we get to a point where through the mediation process, you may find that you have agreement on certain terms as you move through. And one of the key things that I always do, and most mediators will do this as well, they'll say, okay, well, we have an issue as to, let's say, evaluation, but we agree on points 2, 3, 4, and 5. So you always repeat 2, 3, 4, and 5 so we don't have to renegotiate those. And that gives people a sense of completeness. And then when you get to that final, we're good to go, one of the parties would have created a settlement agreement. And that would be emailed over to the other side. They'll review it to make sure the language is how they like. Now, when you're doing a mediation, you're thinking of not only just how much the person's going to receive, let's say, but you want to deal with the issues that are involved. So if we use a wills variation. So typical mom or dad has passed away. They've given everything equally to children 1 and 2 and nothing to child 3. So you're going to want to say, okay, we've agreed that child 3 is going to get X. But then in the terms of the settlement, you're going to say we want the will varied by court order. That clause 2 now says not A and B, but A, B, and C. Okay? And you'll need a court order for that. You're also going to want to have terms such that after that, the litigation is finished. No more, you can't sue me, I'm not going to sue you, we're done. And you would also want to consider, depending on the nature of the estate, if you can, when certain things might happen, like we have to do, should there be an accounting by the executor? So generally when you have an estate and everything's good to go and you go through it, an executor to be released ultimately has to say to the beneficiaries, here's what I've done, this is why I spent this money, and this is what we have to distribute. So you may want to include and ensure that there's an accounting provided by the executor. Sometimes I've said, we'll agree to this, but there'll be no accounting. We're not going to go through this next step of fighting over whether or not, the pencils would cost 5 cents or 10 cents, right? So we don't have it. So you want to try and lock down as much as you can in a settlement agreement.
Right. So can I just follow up with one of those? What is the result when it's unsuccessful? Does it still add benefit?
I think it does. I think it can be beneficial because it allows both sides. See, remember, you're speaking on a without prejudice basis.
Mm-hmm.
So anything that was communicated during the mediation can't then be used, say, when you go to court. You can't sort of, the other side stands up and says, I want X millions of dollars. And the other side can't say, hold it. In the mediation, you only wanted Y. Can't say that. But it gives you a sense of where people are coming from, and also, how forceful they are. I mean, are they really seriously going to take this on or defend it? And it gives you a good sense.
Okay. Sorry.
Or maybe you don't resolve all of it, but some of the issues.
Yes, true.
And so whatever issues you proceed to court with, it would be faster and presumably, hopefully less expensive if you've got fewer issues to deal with.
Well, hopefully. It depends on the issues that you have to deal with.
Right.
And, the other thing is getting in front of the court these days it's hard.
Mm-hmm.
I mean, trials are now at least 2 years away.
Mm-hmm.
Getting in front of judges and just in chambers is very difficult because there's so many people there. I mean, the average people don't appreciate that, court is 4 hours a day, and you can walk in and the list could be 10 hours.
Mm-hmm.
And whether or not you get on or not. And that's very frustrating as well to clients as well, because they think, well, we've got a court date. Why didn't we get a judge?
Mm-hmm.
We're not. And guess, there's your lawyer sitting there all day, still expecting to be paid and not getting anything done.
So are there scenarios or fact patterns where you would say it would not be appropriate for mediation?
I think a comity is the most difficult one. Now, so people don't know what comity is, your listeners, that's where someone is potentially incapable of managing their finances and or their personal affairs.
Mm-hmm.
And so normally when that happens, there's a medical opinions, and the person may object to that, who's being the subject of the opinion, or maybe some family members. And that's difficult because ultimately, who's going to have the decision? If the doctors are coming in on the opinions that the person is incompetent, you have to deal with that.
Mm-hmm.
And you need a court order to have somebody handle things. Now, the interesting situation might be where you might have the person having done a power of attorney and a representation agreement, and then it's someone else who wants to be committee. So the person who's applying to be committee has to give notice to the power of attorney and representative, and they may oppose that. And depending on the level of the capacity of the patient, there is a case out there that I'm aware of where that person was interviewed by a lawyer, and an affidavit was sworn by that person, and it was admitted into court, and all that person was basically saying was, my first choice is this person rather than that person. And it gives you some ideas to why.
Mm-hmm.
And so that's, those are tough. And I don't think I would do a mediation on that.
So what about if there were allegations of fraud or maybe even abuse? Would a mediation be appropriate, or do you think that is better resolved by a court?
If someone's making the allegation of abuse, they're going to have that burden. And that's going to be, it's a very serious allegation. And so it could work out in a mediation because, I mean, I hate to say it, when you're dealing with dollars and cents here, there's not going to be some, acknowledgement, yes, the deceased person did terrible things to you. But, given what we've heard, given the evidence, what would a court do? Court could very well say, given those actions, we understand why that particular, say, child felt they could never be close to that adult, that parent. And so the estrangement is really a result of the parent's actions, terrible actions, and not the person who's been cut out. So it could be dealt with.
How can parties assess whether mediation is suitable for their specific circumstances?
Oh, boy. Hopefully we've got counsel.
Is it normally going to be on the advice of
think,
counsel?
Yeah, I think it usually is. I think lawyers, given the state of affairs with our judicial system and the amount of time it takes to get a trial date and get heard and all the rest of it, mediation is becoming more and more advantageous. And also the bar itself is promoting alternate dispute resolution as a means of resolving things, for all the reasons we talked about earlier today. And I think that's, counsel would be remiss. I've always thought of mediation as a string in my bow. Okay. I'll ultimately go to court, fine. But I mean, if this is a possibility that can help resolve things, we should investigate it. Whether or not the other side's interested, I don't know.
And for mediation, does it always require lawyers to be involved? Must you have counsel?
Well, as a mediator, I would prefer counsel because I can't give legal advice to the people. So they'll, if you've got an unrepresented person, they'll say, well, what am I giving up? Well, that's not my role. And so you might get to a point where if you had two self-represented or a number of self-represented people, that they would all have to go out and get legal advice before they signed any agreement. And then you might be back at square one because someone says, hold it, my lawyer says that's not a good idea for me to do that.
So this has been great. You've given us a very detailed synopsis. Are there any final tips or points you think our listeners should know about mediation?
Well, I think one of the main things is consider it even when you're in litigation. Think about it because it's a potential resolution mechanism. Make sure you've got your ducks in a row, that you feel confident enough that you've got enough information that it's worthwhile proceeding. There's no sense starting off and saying, oh, we don't know this, we don't know that. And raise it with the lawyer that you're going to be retaining and see what their thoughts are. Okay.
Well, Ed, thank you very much. And how can our listeners find you?
Well, I mean, you can go on the internet, a website, North Shore Law, and find me. I'm there. That's probably the best place to get me. I'm not a big, I don't do Facebook and things. But it's good.
North Shore Law in North Vancouver.
In North Vancouver, yeah.
Otherwise, you may get some surfers looking for you on the North Shore.
Oh, gosh.
Thank you so much, Ed. It's been really wonderful to have you.
Well, thank you for inviting me. It's been interesting.
Thank you, Ed.
This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.